Welcome to the Accountants Connection webinar series brought to you by Your Business First, the professional services firm that works directly with the accounting profession. Hi everyone, this is Darren Sherry, CEO and Principal Consultant here at Your Business First. Today's topic is Shareholders Agreements, why you need them and what you need to consider. Presented by Alex Martin, who's the Director of Taurus Legal Management. Hi Alex, and thank you for taking the time to talking to us today at this webinar.
Hi Darren, thanks very much for having me.
No problem. So let's get started straight away. So in today's webinar, Alex is going to give a brief introduction of his business as well and talk about basically what's going to be discussed today. But more importantly, we'll go through the common causes of disputes between business owners, how to minimise the chances of a dispute, how different business structures impact on owners' rights and obligations, how to manage disputes, the kind of outcomes you can expect from a court or via a negotiated settlement, and some tips to avoid and manage disputes effectively. But please, if you've got any questions during the course of the webinar, please click on the Q&A tab, which should be on the bottom of your screen. Enter your question, send anonymously, and we'll try to answer them as we're going along. So, Alex, just first of all, just tell us a bit about yourself and Taurus before we start this webinar.
Sure, thanks Darren. Taurus is a commercial law firm which focuses on small and medium-sized businesses. About half our practice is dealing with disputes, and probably the worst disputes we see are disputes between business owners, hence the reason for this topic. And the other half of our practice is dealing with commercial documents and sales of business and that sort of thing. And so it all kind of hooks into together. If you deal with the dispute, then you can deal with the documents as well, and you know the types of issues that are likely to come out of a dispute, so you can therefore manage the documents better. We do a lot of work in the professional services industry, so we have a lot of accountants as clients and a lot of lawyers and architects and GPs and surgeons and other professional service providers, so we're very familiar with the types of issues that professional services firms face, which can be a bit different to the type of issues that other types of businesses face. And so because of that familiarity, we've crafted a seminar today that's going to deal with the types of issues that an accounting firm might deal with in relation to regulating the different owners in business.
Okay.
So shall we get right into it? In terms of the introduction, today's topic is shareholder agreements. So a shareholder agreement is the main way that business owners regulate their relationship between themselves. You can also have a joint venture agreement, you can also have a partnership agreement or a unit holder agreement, and we'll go into those a little bit later, but effectively all of those documents regulate the relationship between owners. They all cover the same types of issues. In terms of an introduction, I think it's probably worth thinking first, taking a step back and saying, well, why do we have multiple business owners? I think for accountants, it's pretty obvious in a lot of ways. You've got different skill sets. You can have somebody who's very good at marketing or business development, somebody who's very good at the technical stuff. Whatever it is, if you have complementary skill sets, you can really grow the business a lot quicker than you can on your own. You can share the costs of running the business. You can deal with succession planning and exit planning in a way you can't if you're just on your own. But I think the biggest reason, and I know this from experience, the biggest reason to have more than one owner in a business is to share the kind of burden of running a business. It's a huge job emotionally, financially, practically, and to have more than one owner means you can go on holidays. It means you've got somebody to bounce ideas off, somebody to support you, somebody who's in the same boat as you. And so there's enormous advantages to having more than one business owner, and certainly with our clients we've seen small accounting firms bring on extra partners and really grow, and the pie that's shared between the partners becomes a lot bigger because you've got these multiple partners with multiple expertise. You've got the tax expert and the compliance expert and then the more advisory expert or whatever. They're able to cross-refer and just grow the business much better. But I think along with that comes, along with the benefits of multiple business owners comes some pretty significant risks. If you're running a business on your own, obviously you're not going to have a dispute with yourself. But if you're running a business with multiple people, you're at risk of having a dispute. You're at risk also of not having a strong direction. You know, if you've got multiple partners who are all sort of doing their own thing, it's hard for the business to pursue a particular strategic direction because nobody can really agree, or people are pulling in different directions. And then obviously you've got, you know, the business, if it isn't doing so well, you've got to share the profit with more people. So there are downsides to running a business which has multiple owners. So today, really the aim of today is to give you some tips on how to maximise that upside to get the advantage of multiple owners while minimising the downside risks, particularly the risk of a dispute. In terms of, like, if you do have a dispute, that can result in the wind up of a business, the forced buyout of an owner, you know, lack of cash flow, a major distraction from the business operations, and brand damage to the business if there is a dispute between the partners. So the downside risk is very significant, the upside risk is very significant, and a shareholder agreement or a joint venture agreement, some type of agreement between the partners, is really the key way of kind of managing that risk. If we get onto the next slide, the common causes of business disputes. So while I'm talking about downside risk and maximising the upside risk, the best way to do that is to sit down with the other owners and potential owners and agree on the parameters of your relationship and to document that agreement with a shareholder agreement, right? So that shareholder agreement is then going to deal with the key types of issues that are likely to lead to relationship breakdown and are likely to lead to problems. Obviously, all problems are a result of relationship breakdown, but the question is, well, what causes that relationship breakdown? From experience, we know we can categorise almost every dispute we've ever dealt with. Every dispute between owners has been a result of one of these four things. It's financial rights and obligations, so money. It's breach of fiduciary duty, so that's acting not in the best interests of the firm, but acting in one's own best interests. It's a lack of clarity around roles and decision making. So, you know, who decides what? Is everything going to be a unanimous vote or what? And it's changes in life circumstances. So someone getting divorced or someone moving interstate or whatever. So if I just take those four examples and give you some more detailed examples of those so that you can have a think about them. Financial rights and obligations, the obvious one is profit share. Is profit being shared 50-50, or is it being shared on some other basis? Is it being shared based on KPIs? And connected to that is declaring dividends. When does the company declare dividends? Is there a policy around that? One partner might want to reinvest the money. The other partner might want to take it out because they like living the high life or whatever it is. So, you know, profit share and dividend declaration is key. And then on the other side of that, of course, loss sharing. If the company is struggling, how do we deal with that? And capital contributions. How do the partners fund the growth of the business? Maybe there might not be agreement about whether there's going to be buying an office or about expanding, opening a new office or hiring people, all that sort of stuff. Similarly, contracting with related entities, that can be a real issue. If one partner owns a cleaning company and wants the cleaning contract to clean the office, and the other partners don't necessarily agree, and obviously there's a lot of tax reasons why you might claim things on the business, which might make sense, but that might cause friction between the partners. And then access to financial records and that sort of stuff can be an issue as well. In terms of, so they're probably the most common financial rights and obligations, particularly around accounting firms. Accountants tend to be very financially focused and very numbers focused, so a dispute about the numbers can really cause a relationship breakdown. Similarly, a breach of what in law we call it a fiduciary duty. So everyone who's an owner of a company has an obligation to act in the best interest of the company. And when somebody acts in their own interests instead of in the interest of the company, that can lead to a relationship breakdown. So generally, that's around things like using business assets personally, so especially cash. You know, paying for things, paying for personal expense, going down to Coles and doing shopping, or paying school fees on the business. And all of those, these are real examples, right? They seem pretty outrageous, but we've seen, you know, huge school fees being put on the business, and it leads to the partners having a dispute, and it's not clear. Yeah. Oh yeah, we're saying $30,000 in the company credit card school fees, $30,000 school fees, and the other partners aren't doing it, just one partner is. And they say, well, you know, I can tax deduct that. And you say, well, I don't think you can. So some pretty outrageous stuff. The other is taking customers from the business. So, you know, having a side business, if you like, you might say, well, our business doesn't really do complex tax stuff, so we'll give that my side business or whatever it is. Competing with the business, obviously, competition with the business is a key issue. Diverting opportunities of the company away from the company to themselves. So they might say, oh, well, I've got this property development opportunity that's come from a client, which maybe the company wants to explore or whatever it is. So there needs to be clarity around those things. Confidential information that the business has is really key. Disparaging the business can be an issue. So saying, so if you're thinking about, a partner might be thinking about leaving, and they might start telling all the clients that this company's no good and that there's someone better down the road, or that they should follow that partner, the departing partner, if you like. And if they're doing that while they're director of the company, there's real problems with that. And really, in terms of fiduciary duties, any action that intentionally hurts the business owners or the business, or even unintentionally causes damage to the business, isn't in the best interest of the business, can lead to relationship breakdown and can be something that should be regulated through a shareholder agreement. The next really big one, again, very common, is roles and decision making. There can be a lack of defined roles of each owner working in the business. So are both partners equal? Does each partner have a couple of staff that they look after and a couple of clients, a set of clients, or do they share responsibilities in some other way? Someone who's the CEO, the technical partner, if you like, is responsible for day-to-day stuff, and another partner is responsible for winning new work, or do they divide it up in terms of work types or whatever it is? But really a lack of clarity around what everyone's supposed to do, or often people assume they know what that is, but it's never really been discussed, or it might evolve over time. And so a clarity around that can really assist, and certainly a lack of clarity can lead to business breakdown. What often happens is you have some resentment which builds over time, just like in any kind of relationship, whether you're dealing with a marriage or whatever, a little bit of resentment over time which builds and builds, and then eventually everything that partner does makes you angry. And so if they had clarity around who's supposed to do what and what are the KPIs for that really helps. I'd probably say, if you remember one thing more than anything else from this seminar, it's that if you have, say, a 50-50 partnership, or even 4 people, you have an equal number of, an even number of partners or directors, then you need a deadlock resolution. So if you have 50-50 partnership and you can't work out what happens if you don't agree, or you have 2 on 2 and you can't work out what happens if you don't agree, then that really can cripple the company if you can't make big decisions. So what kind of deadlock mechanisms you can have? They're really not as hard as you might think. You can have a third party resolve deadlocks. So you can have a trusted advisor. You might have your financial advisor. I know for our non-accounting clients, we often say the accountant is a good person because they can look at the best interest of the business and make a decision. So you can have a third party that everyone trusts, or you can have a chairman effectively who has a casting vote. And I think it might say, well, whoever the chairman is then gets to make the key decisions, and that might be true, but often it's best for the business just to make a decision and move on, not to get, even if maybe it's the wrong decision, but just to make that decision, move on, everyone accept it, and keep running the business rather than get sort of bogged down in this kind of deadlock, which can really destroy the business. So I'd say making sure that you look at the numbers of decision makers you have, and then having a deadlock mechanism if you need one really is critical to making sure that you avoid disputes and that you're able to, as I say, just move on. Often in business, you make a lot of decisions. Some of them are right, some of them are wrong, but you just need to make the decision and move on, not get stuck on it. If you get stuck on it, then it can really undermine the business.
So this is one of the questions that's coming.
Yep.
Who does chairman be? I mean,
so the chairman really is just somebody with a casting vote. So it might be the founder of the business. You might have 4 partners, and maybe the founder started the business. They might be the chairman of the meeting or have a casting vote if you end up with. So they wouldn't use that vote normally, but if you had 2 on 2, then they would be entitled to resolve that dispute.
It still can be that current shareholder, or
that's right. It doesn't have to be anyone, or it can be, and that's what I'm saying. It can be an independent person. So you might have, say, the firm might have a financial advisor, or the firm might have. I know in my case we had a boss. I was in partnership with another lawyer, and we had her old boss was our deadlock because we both knew him. I'd worked for him at some point in the past. We both trusted him. We thought he had good business judgment in terms of running law firms. And so we said, okay, well, you're the deadlock. So it could really be anyone. Obviously, it's important that that's somebody that everyone thinks is going to make a sensible decision. But as I said, as long as somebody makes the decision and you move on, I'll go into a bit more detail about decision making later. You can have protections, say, for minority shareholders. If you're, one of four, you can say, okay, certain decisions need to be unanimous. So you don't need it. You won't need a deadlock breaking mechanism, and there's certain decisions that everyone needs to agree to. Say to sell the business or to issue more shares or something like that. So there are other ways of protecting kind of minority shareholders or decision makers. Then, of course, related to the roles of decision making is what can be decided by simple resolution. Simple resolution just means more than 50%, and what can be decided by special resolution or unanimous. Special resolution is normally 75%, but it can be any number, and obviously that's the number of partners in the business is going to be really important. You might also think about, when we do shareholder agreements, that you might say, okay, well, I don't need a 75% resolution because I've only got two partners, so it's only ever going to be 50-50. But say, well, in the future you might. So you might have a third partner come on, and then you need it. Say you might put it as 66% or whatever. So two partners have to vote in favour of it. And you might have certain decisions which need simple majority, so just day-to-day stuff. You might need special resolution for certain stuff, and then you might need unanimous if you want to sell the whole business, or if you want to go into a new area of business or do a property development project that's different to what you normally do. That sort of thing. So that kind of roles in decision making and the percentages and how those numbers work in practice is really significant. And then the final thing that we see a lot of is changes in life circumstances. So that's typically someone gets injured, they get ill, there's a marriage or relationship breakdown. Perhaps the business changes direction for some reason, or one owner has a new opportunity. So one owner's brother might approach him and say, I want to do this property development project, and then that might go really well and actually make more money than they're making as a director of the business or as an accountant. And then suddenly their motivations might change. So people might be really aligned, but then because of this other opportunity or because of this marriage breakdown where they're mentally out of the business, or they need money to settle with their ex-spouse or whatever it is, that can really change what was a very aligned business. So we need to consider the kind of what ifs. So it's those four things really that are key in terms of causing relationship breakdown. So that leads us to the next point, which is how do you minimise the chances of dispute? So the best way to minimise chances of dispute is by having an agreement which deals with those sort of things. So the benefit of that is really twofold. One is everybody sits down and comes to an agreement, and in the process of doing that, everybody has buy-in, everybody has a say, everybody's thinking about those things while they're still friends. If you agree at that point, okay, well, if one of the partners exits, this is how we're going to value the business. Then if later on one of the partners is exiting and you then go and look at the shareholder agreement and say, okay, well, this is how we're going to value the business. Maybe it's not perfect, but I agreed to it at the time. You're much more likely to buy in to accept that. Whereas if there's no agreement about that and you sort of at that point don't like each other, then things can sort of escalate. So that process of everybody getting together and making an agreement really aligns everybody, and it gives them buy-in, so that then if there is a dispute down the track or even some uncertainty down the track, everyone can look at the agreement and say, oh, well, that is what I agreed to, so I accept that. And then obviously practically, once you've got an agreement, there's a legal obligation there as well. So you've got a document which will govern how things are supposed to happen. If there's a dispute about decision making or about roles or about someone starts competing with the business, you can open up a shareholder agreement and say, well, look, there's an agreement here that this shareholder agreement says you're not allowed to compete with the business, so you're going to have to stop. And you're more likely to be effective than if you're just relying on the general law or on some abstract claim in law that nobody's agreed to. If everybody sat down and agreed to something, then this is much more likely to be accepted by the parties. I might go through at this point, I think, probably some of the key issues that shareholder agreements do address. So you can see them on the slide there. They're some of the key issues, but it's probably worth just going through the kind of topics. So a shareholder agreement obviously will address the sorts of things that we've raised, but they'll address them in a sort of a different way. It's not just going to have a heading saying fiduciary duties. It's going to deal with things in a set of topics, if you like, which I'll just go through now, which is helpful. Yeah. So the first thing is the parties. Who are the parties to the shareholder agreement? That might seem obvious, but it's not necessarily. You might have individuals, you might have companies, you might have family trusts, who are their contact details, all that sort of stuff. So we know, well, who are we dealing with? That's pretty straightforward. And then then the business purpose. So what's the purpose of the business? And this is really critical in in terms of just good governance of a business. You do need agreement and alignment between all the partners about business purpose. And it might be assumed, but I wouldn't necessarily assume it. And that's actually something Darren can help with and does in his sessions where the partners get together and work out what the purpose of the business, what they're trying to do, and trying to get alignment between the partners, which is really valuable. So is the business to try and make as much money as possible and get cash out, which some partners want, or is it to build it up and to sell it? You know, is it to manage some assets? You know, I mean, are we really, you know, managing the office or whatever that we own, or, you know, to what extent is the aim of the business to generate cash, and to what extent is it to increase the capital value of the assets it owns? Whatever it is, you need to agree on those things. So the business purpose is really critical, and a lot of business decisions come back to, well, what's the business really about? What are we trying to achieve? And if you can measure it according to that, and that's some objective agreed, you know, it's say to generate as much cash as possible for all the owners to get the biggest dividend every month as possible. That's an easy thing to measure success by. So you can. Whereas if it's unclear, people suddenly start going, well, I don't want to buy that new IT equipment because it's going to reduce my dividend. And other partners might say, well, I thought we were trying to, you know, build the value of the business itself. So, okay, yeah. So business purpose, you know, business name and all that sort of intellectual property stuff is important. Term, is this something that's going to go on forever? How do people get in and out of the shareholder agreement? Will it last forever? Does it have to be renewed? Is there a particular project that needs to be finished or whatever as part of this agreement? Financial contributions, so that's obviously critical. We talked about that, you know, what capital is going to be contributed by everyone, how's the business going to be funded, what are the obligations of each of the shareholders if the business needs additional capital, that sort of stuff. Who's going to own the intellectual property? Who's going to own bits of the business? Who are the directors? How will they be elected? What are the functions of the directors? How do they make decisions? Again, by majority vote and all that sort of stuff. Do they have a limitation on their powers? So it might be that you have, you know, it's not uncommon to have even accounting firms. You might have 3 partners, and you might have 2 or 3 silent partners, or partners who are semi-retired or whatever. What are their obligations? Maybe they don't have a vote on the board anymore because they're semi-retired, but they might have founded the business and be really central to a success, so they might still get dividends from the business. But you want to deal with all of that in a sort of in a written agreement. What decisions require shareholder approval and what can be decided by the board? Again, can be an issue if you've got kind of shareholders who aren't actively involved, who aren't on the board. You might even have a technical sort of person who doesn't want to be involved in the governance of the business. They just want to sit and do their work, but they're very valuable to the business and you want to give them equity. So they might be a silent partner if you like. Certain things may need to be run by them. Maybe they don't. But again, that's something you want to be explicit about. Profits and losses, which we talked about, obviously, that's critical. You know, when a dividend's declared, are they going to be reinvested? What's the decision making around that? Do you need unanimous decision to decide to declare dividends, or is that something that can be made by simple resolution? How do you have meetings? You know, are there going to be a meeting monthly? Can there be meetings be called? What's the notice provisions? That sort of stuff. Can the business be sold, and in what circumstances? And will there be preemptive rights to purchase the business from other shareholders, or what they call drag along and tag along rights? So if, say, you've got 3 owners and 2 want to sell it, and are they allowed to drag the other owner along to force the sale or not? And that really depends on what the purpose of the business is again. So if the plan was to sell the business, it might be reasonable that 2 partners could force the sale of the business, force the 3rd person, because the sale was always the issue. The plan, it was really just that maybe the 3rd partner didn't agree to the price. But if the plan was always to keep the business, then maybe you need a unanimous decision to sell the business, and you wouldn't have drag along and tag along rights. Responsibilities and duties, which we talked about. You know, who prepares the budget and the business plan? Does that need to be signed off by everyone? What responsibilities do the partners owe? What duties do the partners have in relation to the daily management of the business? That sort of stuff. Restrictions on powers. So can partners engage in other, you know, employment and subcontracting whilst they're whilst they're part of this business? You know, can you do some accounting on the side? Is that allowed? And then probably one of the most critical ones is new and departing shareholders or partners in the business. You know, how do new shareholders get added? Does a shareholder need to give notice if they want to leave? What rights and responsibilities do incoming and departing shareholders have? You know, are they still going to be liable for personal guarantees, all that sort of stuff, or are they going to be immediately removed? Normally they'd be removed. What indemnities do they get? That sort of stuff. Typically, all the partners have to sign up to, you know, bank guarantees and lease guarantees and all that sort of stuff. So you want to have an indemnity in this agreement. So if I resign as a partner of my accounting firm, I'd like to be indemnified immediately as part of the shareholder agreement to any guarantee that I'd given, you know, which seems to make sense to be indemnified by all the other partners. Because often it's a real pain to actually get someone removed as a guarantor by the bank or by the landlord. So having an indemnity in that document, it just makes sense. How can a shareholder be removed for doing the wrong thing? So is there automatic expulsion of a shareholder if they become bankrupt, or if they breach the shareholder agreement, or if they're ill or incapacitated? And then intellectual property and so on. So if there's intellectual property which is created, is that just owned by the business, or is that owned by the particular partner? Or would that be, sometimes you've got a founding partner who wants to own that intellectual property and then new partners come on, that sort of stuff. But they're the key topics that a shareholder agreement is likely to deal with, which should govern most of the things, most of the what-ifs, if you like, that can come up in business. And that hopefully will give you a kind of a, sometimes you just do the shareholder agreement, you put it in the bottom drawer and you never look at it again, and that's fine. But it'll give you a hopefully alignment, so that then when you're running the business, you know where everyone stands, and if there is any confusion, you can pull it out and have a look at it. Okay. And I should say, a shareholder agreement doesn't stop you from making other decisions. If there's 4 business partners and the shareholder agreement says, you know, this valuation methodology needs to be applied if one of the partners is leaving, and all of the partners agree that methodology isn't appropriate anymore, they can change it. So they can either change it in the shareholder agreement, or they can just agree not to enforce it. And if everybody agrees, then there's no problem. It's only if one person doesn't agree that then the shareholder agreement becomes significant. So you're not bound by, or you're not stuck with the terms of the agreement forever necessarily. So I wouldn't be concerned about having a shareholder agreement. And really, every time somebody rings me and says, I've got a dispute between business owners for you, the first question I ask is, do you have a shareholder agreement? And inevitably the answer I get is always no. So the kinds of people, in my experience anyway, who do shareholder agreements, who are thorough and who plan ahead, actually much less likely to have a dispute in the first place. So, as I say, the process helps you avoid a dispute, but you know, that kind of prudent sort of person who does that sort of stuff often doesn't have the disputes. And if they do, then if you're able to pull out the shareholder agreement, it really guides you through how that dispute needs to be resolved. So there's sort of an umpire, or at least a rule book that everyone can consult, which everybody's agreed on and everybody's bought into. So it really helps.
Another question has come through, Alice, is, for example, can the shareholders agreement be changed or reviewed on a regular basis?
Yeah, it can. So you can have a term in the shareholder agreement. I've done some of those that say, look, this shareholder agreement lasts for 4 years, you know, or whatever it is, and then it needs to be renewed, otherwise it automatically terminates. So that can happen. I wouldn't generally recommend that unless there was some reason for it, because you wouldn't want it without, no one's even, you know, everyone's forgotten about it in 4 years and then it terminates and it no longer got any protection. I think you're better off having something in place, even if it's not ideal. And even, I should say this as well, even if you negotiate with your partners, most of the terms, maybe there's 1 or 2 that are sticking points, you can sign an agreement that just leaves those terms out. And I would recommend very highly doing that. So I've had a couple where, you know, for whatever reason, say the deadlock mechanism couldn't be agreed. And that meant that the partners then just procrastinated and never signed anything. And that meant they had no agreement in place. So it meant they had no protection at all. And I'd say, well, just leave the deadlock out, sign that one. And if you can come up with a deadlock mechanism later, then we can sign a new one. And at least then maybe you can't resolve any deadlock issues, but you can resolve any other issue that comes up. And so I very much recommend keeping something. You're much better off having something that's imperfect than having nothing at all. But yeah, you can certainly review it, and you can provide mechanisms for review in the agreement itself.
Okay.
So that leads on to the next point. Now, I've included some information about business structures here. That's more for, I mean, as accountants, most of you know a fair bit about business structures already, and I don't want to tell you how to suck eggs. But this is more if you were to use the notes from this with your clients, that's just something to be mindful of. Obviously, if you're in a sole trader situation, it's not ideal for having multiple business owners. A company is a very straightforward one where you have shareholders. A partnership does impact. There's a Partnership Act which impacts on the way individual business owners relate, and it actually impacts on the way that the world at large can deal. If you're a genuine partnership under the Partnership Act, then partners can bind all of the other partners, and so you could have one partner who goes and buys a expensive property or whatever, and all the other partners are stuck with that debt. So that can be a real problem. So partnerships do have different features which are worth being aware of. And then trust, obviously a very common one, where an entity holds property for the benefit of others. All of those, so if you were dealing with a company, you'd have a shareholder agreement. If you're dealing with a partnership, you'd have a partnership agreement. If you're dealing with a trust, if it was a unit trust, you have a unit holders agreement. And all of those documents are very similar. They cover all of the same issues that I spoke about. There are some peculiarities to do with partnership law and so on, but ultimately, whether you're a shareholder or a unit trust, you've got units in a unit trust, the issues are going to be the same, and the relationship's going to be the same. The relationship breakdown's going to be the same. So I think it's just worth mentioning there are different structures and they're relevant. Probably more relevant for for something to talk about with your clients, but as accountants, you're probably going to know the basics of those already. So that leads us on to managing disputes. So what do we do if there's tension between the owners or if a dispute arises? So sometimes owners come to us because there is tension in the ownership group, and the process, as I've discussed, the process of negotiating a shareholder agreement can actually diffuse that tension and can lead to a reshuffle of owners. So we might have one where we had one just recently where the owners were going to bring in we're effectively merging with a guy who was running a financial advising firm, and they were becoming one firm. And through the negotiation of the shareholder agreement, we realised this wasn't a good idea. So what he expected from the merger and what the partners expected wasn't the same thing. And so we ended up not going ahead with that, but that was a dispute waiting to happen. If they'd just done that, it would have led to the breakdown of relationship. So the negotiation helped us identify that, and going through the shareholder agreement kind of negotiation can help diffuse tension and can help everybody sort of get along. Although if a dispute's progressed to a certain level, then negotiating a shareholder agreement isn't going to work because everybody already hates each other. So if you've got it in a situation where a dispute that can't be resolved easily, I've got some tips there on what you need to do. And the first and foremost issue is to understand the real reasons that the partners are in dispute. So as you know, going into business with someone is sort of like a marriage, and often it's that you might be arguing about money, but it's not really about money. It's about being listened to, or it's about feeling pushed around, or whatever it is. So you've got to understand the background and the real issues in dispute. What's really going on. I've had one where it was to do with the partners were brothers, and it was to do with their mum passing away and how one of them had dealt with the mum passing away and the funeral arrangements and all that, and they hated each other, and nothing we could do would stop them hating each other, and they were just fighting, using the business as kind of throwing mud at each other when really they were upset about family issues. So we've got to kind of acknowledge that, and in that case you go, okay, well, if I know the real issues in dispute have nothing to do with the business, then one of them just has to exit the business. That's the only way around it. So understand the real issues in the background of the dispute is number one. Sometimes that's not obvious to you, but I think if you're involved in it, you might just say, well, this person's just very difficult, but you might not actually realise. So sometimes talking to somebody else can help, or to a lawyer can help, to see that the lawyer might say, well, I think what you're saying to me is that the other guys don't listen to you, or that they're not taking your point of view seriously, and them doing that over the years has really upset you. And so now it's built up to something else. And so maybe if we had a shareholder agreement that where everybody had a vote, you'd feel listened to and that'd be all right. Or maybe it's gone beyond that and there's nothing you can do. So understand the real background of the issues, then you locate the relevant documents, and of course you won't have a shareholder agreement if you're in a dispute. Hopefully you have a look at the constitution and the trust deed or whatever it is, or it could be the relevant legislation. The Corporations Act sets out what directors can and can't do, and then obtain an independent valuation. The reason I say that is because ultimately where disputes are very difficult, where a dispute's not easily resolved, it'll usually end up in at least one business owner leaving and then getting paid out for their shares or their units or whatever. And so an independent valuation will give you a kind of a yardstick for that payout. And that's how almost all of these things get resolved. They get resolved through a partner leaving and being paid out. So it often comes down to a question of how much you pay them. And so an independent valuation, even though they're often expensive, can be very helpful. And then I'd just say try and use objective standards. So saying, subjective value judgments about what everyone's done and hasn't done are really pretty unhelpful. You want to try and stay objective, stay focused on the kind of key numbers, and then have an early mediation if you can, and use your valuation and your objective measures to say, okay, we're going to give you X amount of dollars to leave, or I'd like X amount of dollars to leave. And I think everyone needs to accept that that's the likely outcome. If you're in that kind of really difficult dispute, it's unlikely that you're going to all hold hands and be friends again. And if you are, you're probably never going to trust each other again. So you're probably best off going your own way. So,
how important it is to have something like a chairman or a mediator, so to speak, as part of your shareholders agreement, if there's some sort of deadlock or...
Yeah, well, a chairman will certainly resolve the deadlock. Now, it might not resolve the underlying dispute if ultimately someone's feeling that they're not listened to, say, and then the chairman outvotes them. Now, it'll get you to continue on with the business. And look, if everyone can just live with that and move on, great. But if the underlying issue is that person feels sort of undervalued or whatever, then I think you're going to have to... But then what you do is move to the exit arrangements, and you say, okay, well, my shareholder agreement says I can exit, and if I exit, my shares are worth this according to this valuation methodology. So I can say to the others, okay, I'd like $300,000 for my shares, please. They say, oh yes, we agreed to that. They pay you out, and off you go. So it's sort of, so I think having those kind of mechanisms in place really helps things not get out of hand.
Yeah.
So very helpful. That leads me to the next outcome. So you don't want to go to court. If you can, anything you can do to avoid going to court is a good idea. The reality is, in this jurisdiction, the court has very broad powers to make a lot of orders. So if you end up in court over an ownership dispute, the court can wind up the company. They can adjust shareholdings. They can remove directors. They can compel people to do things. They can take charge of the company affairs and appoint an administrator. But what they'll normally do is either force a buyout based on valuation evidence, or they'll force the company to be wound up. And so obviously that's can be very damaging for everyone. A court-ordered remedy is usually going to be the sale of shares or the wind up of the business, and that's going to it's sort of like a hand grenade. A resolution that's going to kill everyone. The wind up of the business is really a negative outcome. So I'd always say negotiated settlement's better. Also, if you negotiate an outcome, although you might not be very happy with it, you at least accepted it. You had some control over it, and you're likely to be able to live with it better than a court-ordered outcome. And the court-ordered outcomes end up being kind of similar to the negotiated outcomes. They just cost more to get to because you have to have a legal dispute, and legal disputes also take a lot of time, cost a lot of money, a very big distraction, and there's a whole bunch of process that you need to deal with, which is really a distraction from the business. So I'd say the last thing you want to do is go to court, and certainly, I mean, I've had a lot of clients who've come to me and said, I'm setting up a business, or I'm bringing on a new partner. What do you think? And I say, I think you should do a shareholder agreement. And they say, yeah, I don't really want to spend the money. So okay, and then they end up in something happened, they end up in a dispute, and then later on they say, well, that it's quite a small amount of money to spend to avoid this very difficult outcome. And that's certainly very common that if things get out of hand, it can cost you a whole lot more than it would have to avoid in the first place. But as I said, it's not just about avoiding the downside. I think the actual shareholder agreement is really quite a positive document which helps you align the partners. And it can be part of a broader thing that you can do with your business first, or with whatever advisor you choose, to help get everyone aligned about the business purpose and about their roles and responsibilities, and get everyone fired up about being successful, rather than just kind of plodding along in your little silos, which is often the way that accounting firms work. So that takes us just as a kind of wind up of the overall tips. My tips, and this is from experience dealing with accounting firms as clients doing documents, and as clients dealing with disputes. First thing I'd say is plan. Have a think about, plan. We can send you a checklist, and you can plan, what do you want to do about financial contributions, directors, profit and losses, plan all of that stuff before bringing an owner on, before starting a business, and then enter a written agreement. the written agreement's really critical. You can have a lot of verbal discussions, and people can take away, without lying or misleading anyone, they can take away what they want to take away from those verbal discussions. Whereas you've got a written agreement, it's all there in black and white. And then part of that is just considering got to be very practical about what implications are. The number of owners, what implications do the number of owners have? If we've got a 50-50 partnership, obviously that means if the two parties don't agree, you can end up in problems. And be clear and explicit. Don't assume about roles and responsibilities. I wouldn't assume that one partner's going to be the technical partner and they're just going to do work all day and have no influence over running the business because that's what they like to do. I think if they've agreed to that, that's great. And if that's set out in the shareholder agreement, no problem. And their KPIs might be, doing X amount of billable hours a month, whereas the KPI of the marketing partner might be to bring in an X amount of dollars or whatever it is. But if you're clear and explicit about that really helps you be aligned and to be successful and to hopefully be excited about coming into work. And then be objective in terms of assessing performance. So that's the KPIs thing. And have, if anything goes wrong and you've got an exit mechanism in place together with an evaluation methodology, then you're in really good form. If the worst happens and somebody's unhappy and wants to leave, you say, well, you can leave and here's how it works. And that can, I know we've had some questions about insurance, but that can also be, insurance can play a role in funding that buyout. So we'll deal with that when the questions come in. And then the other thing I'd say is if there is problems, if somebody's upsetting everyone or somebody's feeling upset, you've got to deal with those issues early and objectively because they do fester. I've got one at the moment where I've had two brothers who have been in business together for 20 years and now they can't go to family occasions together because they hate each other's guts. The brother who I'm acting for said to me, my brother is dead to me. Right, he's dead to me, which it's just a shocking position. Been together in 20 years, no shareholder agreement, everything was okay for the first 10 years, but then really the second 10 years things festered. My guy felt excluded from the decision making. He was more sort of focused on the work, and the other guy was more a people person, if you like. And so then he's really nicked off. The people person has nicked off with all of the clients, or a lot of the clients, and my guy's now really stressed, not sleeping well, can't go to family occasions, not dealing with his brother. His business is crippled, all the areas of his life are all going badly at the same time. His office is owned by the business and all this sort of stuff. So and we'd all know that if one area of your life's going badly and the other areas are okay, you might have a tough time at work, but if at home everything's okay, then you feel all right. But if all of the areas of your life all collapse at the same time, it really puts a huge amount of pressure on you. And so he's really struggling with it. And so that's something where, 10 years ago, they really needed to deal with those issues. But it also goes to show that a mature business can still benefit from a shareholder agreement. So we have some clients come to us to do shareholder agreements at the very beginning when they're setting up the business. Some who come to us to say, I want to bring a partner on, and the partner, it's say 100% owned by one partner. They want to bring a new partner on, and obviously the new partner is saying, well, how does this all work for me? And to protect that new partner and to protect the old partner, they introduce a shareholder agreement, which makes a lot of sense, or to bring on an employee and to make them an equity owner. So at that stage, and then some at the more mature stage, you just say, I think it's time. Or we even had one recently with, it was actually two financial advisors rather than accountants. And one of them had a family, a family tragedy, and he wanted to work less and spend more time on a charity venture so he'd gone from being a 50-50 partner really to wanting to kind of run his own business, run his own charity and spend, 20 or 30% of his time doing servicing his current clients. And so we kind of created this shareholder agreement which allowed him to continue to do what he wanted to do and the other owner to take more control over the business. And we sort of crafted that to suit them so that although they'd been 50-50 and they'd been happy for many years, now things had changed. There'd been a personal, change in personal circumstances, and we were able to craft a shareholder agreement that meant that they were both happy with the new outcome. Whereas I could see the owner who was who now owns more of the business, he was getting upset at the other fellow, although he was sympathetic to what had happened in his life. He was saying, well, hang on, you're not turning up to work nearly as much as you used to, you're not going out and winning new work like you used to. You know, he was starting to resent him. And by creating this arrangement, then they both felt kind of fairly dealt with, and they both are able to run the business successfully. And it's still running now, and it's very successful. And you know, so I'd say, you know, your shareholder agreement can be introduced at any time. You don't have to. It doesn't have to be at the start of the business. It doesn't have to be at the end. It can be sort of at any time along the way. There's benefit to doing a shareholder agreement or whatever agreement. There's benefit really to the partners sitting down. And again, I'd say that I'd recommend you talk to your business first about it, about everybody sitting down in a room and saying, you know, who are we and what are we trying to achieve? You know, what's our goal here? You know, do we want to just run the local accounting firm that services the local community and, you know, do okay? Or do we want to open a national firm that's going to grow and make millions of dollars? Or do we want to just earn enough money to pay our rent and to build the value in the office we own? Or, you know, does the older fellow want to retire soon, and do the younger people want to take more equity ownership? Like, what's the plan? And once you've got a plan, then you can put the shareholder agreement, the documents in place, and then it will work towards the plan and hopefully build a business that's very valuable.
Questions? Oh, thanks very much for that. That was great, Alex. Thank you very much for providing that information. So we've got a couple of questions that are coming through, but one of the questions I've got here is that from a maturity point of view, or from an established business, and from your experience, how difficult has it been to create a shareholders agreement for those current partners or current directors?
Yeah, so that's a good question. So for the more mature businesses, sometimes it's a lot easier because everybody's in the groove and they know what to expect. And sometimes it's harder because there's some assumptions that they've made, and perhaps they've all been doing their own thing for many years, and there's a lot of stuff they don't agree on. So it sort of depends. If you're dealing with where everyone's in the groove and you're just formalising something that's been in place, like effectively by understanding, then that's easy and it's cheap because the partners just say, this is what we want to do, this is what we've agreed on, boom, boom, boom. We've filled out a checklist, we've tick, 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 and here's our agreement. So that's probably easy and cheap. Still worthwhile because then it's all documented. Whereas the ones where everyone's doing a different thing, it can be more difficult, and that can lead to things, issues bubbling to the surface. I'd say that, I mean, you might say, well, we don't want the issues to bubble to the surface, so we'll just leave it. Maybe, but I think a lot of the times those are issues that are going to upset everyone at some point. You're better off everyone talking about it while you're friends rather than resenting each other. You know, so I think that process can be difficult. It can be a bit confronting, but I think it's worthwhile because then you go, okay, well, now it might even be that the shareholder agreement says, look, we're 4 different partners operating 4 different silos, effectively 4 different businesses, and we're sharing costs. No problem with that at all. That's fine. That's a lot of accounting firms operate like that. Nothing wrong with that. But then it's clear that's what everyone's doing. So everyone then, you know, is effectively competing with each other for clients and whatever. That's fine. A lot of law firms run like that, and they run very successfully. You kill, what do they say? You eat what you kill, all that sort of stuff. That's fine, as long as that's what the agreement is. So I'd say in those ones where there's sort of a lack of alignment, but getting alignment is still really important.
Okay. And another question that's come in through the registration process is about insurance.
Yeah. So we've had a couple of questions about insurance. So you can have insurance as part of a shareholder agreement. Sometimes it's part of what they call a buy-sell agreement. A buy-sell agreement is effectively a sort of a miniature version of a shareholder agreement. It covers some of the things a shareholder agreement covers, and it's normally connected with insurance. So as part of your shareholder agreement process, I would recommend that you get insurance, and that's insurance to fund a buyout. So it's called buy-sell insurance. It's designed to manage the risk to the business if an owner is forced to exit because of illness, injury, or death. So buy-sell insurance pays a lump sum that ensures that the remaining owners can acquire the departing owner's equity and continue to run the business. So if the business is, especially is very valuable, it might be that the remaining owners can't afford to pay out the departing owners or the owner who's ill. So they take out insurance to enable them to meet that payment, and it also enables then an agreed compensation amount to be paid to the departing owners, to the departing owner if they're ill, or to their family if they've, or to their estate if they've passed away. So they're sort of like a business will, and they can help minimise the risk of remaining owners needing to sell the business if someone leaves or if someone's ill. or cover the risk of having to take out additional borrowings to pay out the departing owner. The other risk is that the departing owner's family become a kind of an active part of the business, which you might not want. So someone's ill or dies, and their estate then might say, "Oh, actually, I want to start being involved in this business because I own 50% of it," and so it covers that risk. So that kind of insurance is very helpful, and I think covers a lot of it. It's all about illness, injury, or death. You can't get it if a marriage breaks up or whatever. So it's about really where somebody's unable to continue in the business.
Okay. Another question that's come through, Alice, is that no question the importance of the how important the agreement is, but many clients have balked at the cost. How do you overcome it?
Yeah, it can be the shareholder agreement's costly. So there's probably two things I'd say about that. Number one is if you can get alignment from people up front, or they can get alignment amongst themselves about the various issues, then the cost is much lower. So what we would do normally is we have a checklist effectively that we'd send to the partnership. We'd normally have a quick meeting with them all to explain how it all works, give them a checklist and say, can you work through this yourself? We're not involved. Work through this yourself. And if they're able to sort of agree on how many directors they're going to be, what resolutions are going to be required, how profit and losses are shared and all that, they're able to agree on that amongst themselves because they're all commercial things, and then give us back the kind of answers to the checklist, if you like. We can prepare a document that's quite low cost. So that's one way, if everyone agrees or is able to agree. Where the cost comes in is where individual partners need a lot of advice about different options and all that sort of stuff. That can then mean that the whole process becomes longer and more expensive. So I'd say if you can get alignment yourselves, that keeps the cost down. And then secondly, I'd say, well, yes, there is a cost associated with it, but I'd say, well, what's the cost of not doing it? What's the risk of not doing it? If you're setting up an accounting business has normally got quite good margins, quite successful. If you can get alignment amongst your partners and everybody be working towards the same goals, and at the same time avoid the risk of a dispute or minimise the risk of a dispute, there's real value in that. And if you sort of are not in a position where you say, well, I don't want to pay for that, you think, well, should you be in business at all? Like, ultimately, you really want, if you want everyone together, working together and heading in the same direction. And if they're not aligned, then maybe you should be in business on your own. So that's what I'd say about that.
Okay. And the other thing too is that's come across is that, I suppose it's from your experience, the shareholders agreements or partnership agreement, unit holders agreements being prepared, but down the track there's been some sort of argument or dispute, but a majority or however the outcome to be resolved has been resolved. Going further, taking it to court, chance of success.
So if you've got a unit holder agreement, say, that's signed, and then there's a dispute and somebody has breached the unit holder agreement, was that the question? Yeah. So if you have a unit holder agreement that says certain things need to happen and then they don't happen, then your chances of success in court are very good. Obviously, it's a matter of evidence around what that person's done and whether you can prove that they've stolen the clients or that they've bought the car with the company assets or whatever it is. But typically you can prove those things. And if you've got a written document that they've signed that they haven't, that's, as far as you ever get in a legal case, that's a very good case. The much more difficult cases where you don't have the signed document, or you have the document that was drafted and floated, sent around a bit, but never actually signed off. And then there's argument about whether they're bound by it. If you've got a document that it's clear people are bound by it, and then you've got evidence that they haven't complied with it, then you've got a very good legal case. And the remedies that the court can give you are very broad. So the court actually take a very dim view of people breaching shareholder agreements and also breaching their fiduciary duties to the company, not acting in the best interests of the company. Often in commercial life, we're fairly lax about it. Commercial business people say, oh yeah, if you've got a related company that's billing us for something, that's all right. That's quite normal. Maybe that related company's doing a great job. But the courts take a much more kind of ivory tower view, and they'll be very unhappy with people who are creating advantages for themselves at the expense of the company. So I think the chances of court are good.
Okay. We've got a couple more minutes if there's any further questions, so please feel free to enter your questions. I'll leave another minute for you to ask any questions.
There was one other question that I saw that came in earlier about transition of employees, transitioning employees to ownership, and I thought that was a good one, and that's certainly something that I'd encourage it, and I think it's a great idea for a lot of businesses. You've got a key employee who's doing a great job, and you want to bring them in and give them equity to reward them. That can be done as part of a shareholder agreement. So the first thing I'd say is you need a shareholder agreement to do that, because that owner's coming in is going to want to be protected and make sure they're not just going to be walked all over in terms of decision making. And then the shareholder agreement can set out KPIs and say, if you meet this KPI, then you're entitled by 5% more or 10% more and at this value. So that can be all part of the shareholder agreement. Or you can have a shareholder agreement and then a separate, like a buy-in agreement, like a purchase agreement. So they're all things that can be done.
Okay. Well, Alex, I think no other questions have come across. So thank you very much for taking the time to present today. I think a lot of, and even judging by the questions that have come across, a lot of people found it to be of value. As a participant in today's webinar, Alex has kindly provided an offer to those participants from Your Business First, and which is a complimentary review of your shareholders agreement. Would you want me to go through this slide?
Yeah. So what I'm offering really is, if anyone who participated today, if they'd like us to either have a look at their shareholder agreement or their queries in relation to a shareholder agreement if they don't have one, or similar, whether it's a joint venture or whatever, I'm happy to have a look at that, review it, come up with some sort of recommendations and ideas, and then have a chat with you about it to see if there's something that's worth improving, and happy to do that all on a complimentary basis. Obviously, if it then leads on to us having to do a new shareholder agreement or whatever, then we can have a discussion about fees. But certainly, we're happy to look at a shareholder agreement or a list of queries and review them on a complimentary basis. And I'd be keen to hear from people on the telephone about how they felt today went and about how they feel about their own arrangements in their business. And I'm certainly to help them without charge.
Thank you. Yeah, so email your shareholders agreement or the list of queries to inquiries@yourbusinessfirst.com.au, and I'll make sure that Alex personally receives that, and he will review and take it from there and organise a teleconference with you. So once again, thank you very much for your time today, Alex. It's been absolutely wonderful. This has been the first of the Accountants Connection webinar series. So there's a lot more great speakers and business people like Alex will be talking down the track. So keep track and make sure you keep a lookout from our emails. Thank you again, Alex. Thank you very much, everyone. Anything on your side?
I'm glad I've answered everyone's questions. Everyone's got no more questions, so I'm very pleased that I've either bored everyone to death or they've got no more questions. That's great. Thanks for having me. I appreciate it.
No problem at all. Thanks very much, everyone. Enjoy the rest of the day. Take care.